Respondent as Claimant and the State of Mauritania as Respondent. Would Claimant please introduce the team and indicate if there's been any agreement in relation to allocation?
Certainly, thank you, Madam President. My name is Mr. Moranis. My co-counsel is Roger C. Banerjee, and the remainder of our team, June Huang, Sarah Cannon, Sarah Weiner, and Tony Tsvetanova. And we have agreed on a breakdown of time. It's a bit unconventional because we are arguing different sections, so we've listed it out. Hopefully, oh yeah, I think we should copy it.
Yes, sure.
So there we go.
Okay.
While I look at this, maybe my team can have a look. Could the Respondent introduce their team, please?
Thank you, Madam Arbitrator. My name is Karyl, and along with my co-counsel, we've represented the Government of Mauritania, and we are also joined by Nicole Franklin.
Does the time, yeah, but does the time work out?
Yeah, I hope so. I don't know. My phone isn't that new anymore.
Okay, so it's going to start. The Respondent will start speaker one, and you're going to start with jurisdiction.
Yes, Tribunal, I'll be discussing the constitution of the claimant as an investor under the treaty, and that will be followed by my co-counsel Stephen Moore, who will be addressing the issues that arise out of the share purchase agreement.
Right, so you'll have 14 minutes on together on these two
Yes.
issues. Right, and then it will switch to the claimant side, and you'll have 18 minutes on those two issues.
That's correct.
Okay. And then it will go back to you on which issues?
I will then deal with the matters regarding expropriation and fair and equitable treatment.
Oh, sorry. I think
That's incorrect.
at that point, I think Claimant will present its merits and damages, but first there's a rebuttal.
Sorry,
Oh, that's
the
the rebuttal.
Respondent
So
will
you'll do a quick rebuttal
Yes.
of those issues. Oh, I
Of the
see.
jurisdictional issues.
Okay, so you're going to get that all out of the way.
Yeah.
Right, got it. Okay. And then we'll go to you for
Yes.
your substantive.
Yes.
21 minutes and merits and damages.
21. Oh, so you do merits and damages.
I'll bring them together.
And we'll come back to you and you're splitting merits and damages.
Yes.
Okay. No problem. And then you'll have your 60 seconds each. Okay. To win the case. Now, as you know, by agreement of the parties, we have very unusually allowed members of the public into this hearing. I expect members of the public to restrain themselves during the course of proceedings, and you can make your feelings known at the end. Okay, so we'll now open these proceedings. Are the transcribers ready? Can I hear from the Respondent?
Yes. Thank you, Madam Arbitrator. The first issue I shall be addressing this afternoon is the capacity of the claimant to bring these claims. In order for the claimant to have jurisdiction, the tribunal needs to find two elements. Firstly, that the claimant is an investor, and that it possesses an investment in accordance with the bilateral investment treaty. Tribunal is a submission of the Respondent that the term investor should be interpreted in good faith, as provided for by Article 31 of the Vienna Convention on the Law of Treaties, and in particular should not protect companies that have engaged in an abusive process in order to obtain standing in a foreseeable legal dispute. The tribunals in Phoenix Action and Pacific Rim have considered a number of factors which are demonstrative of the abusive process, and as such which operate to bar an investor seeking protection under the BIT. Now, the first one of these factors I shall consider today is the substance of the transaction itself. If I could please direct the tribunal to turn to page 24 of the record. Now, this particular letter outlines was a letter sent by the by the General Counsel of FBI to the Chief Executive Officer, Mr. Goodfellow.
Can I just interrupt for one moment? Is it agreed between the parties that this letter is admitted in these proceedings, or is there a dispute about that?
Claimant does not dispute the admissibility of the letter at
Okay.
this point.
Madam Arbitrator. Now, it would seek to note that this letter states that following a meeting, the individuals in question were seeking to acquire further protection for the contingent group. Now, at the end of that letter is also buttressed by the particular statement that the individual recommended Kronos, Delaware, and Switzerland. It is a prior finding of this tribunal itself that those three jurisdictions all possess a bilateral investment treaty with Mauritania. As such, it is a submission of the respondent that this party was simply seeking to acquire legal protection in anticipation of the dispute.
Counsel, I'm at a loss how you get to anticipation of the dispute from that.
At Tribunal, it is our submission that the sole purpose of the incorporation was to acquire protection under the BIT. And we believe this letter is demonstrative of the fact that was the guiding principle for this particular outcome.
But what is wrong with seeking protection under the BIT?
Prima facie, we recognise there is no bars to investors seeking protection under a BIT. Rather, we are submitting that where investors engage in an abusive process, as distinct from the ordinary corporate restructuring, that in that case their claim would be barred.
When did they decide to get protection under the BIT?
It is our submission they sought to acquire protection under the BIT 1 month after the New Way Party was elected, after campaigning on a platform of limiting the advertising and marketing of alcohol in Mauritania. Sorry, incorrect. Tribunal, now I may anticipate that the claimant may perhaps suggest there are a number of other factors that were considered in this letter, but we would submit that these factors were largely used to determine which legal protection they sought, as opposed to being determinative on the country where they incorporated. Another relevant factor in determining the substance of the transaction is the amount paid for the particular acquisition of the shares. Now, we note from cases including Bakes and Turkey that where a nominal amount is paid, it is indicative that it is not a legitimate purchase, rather is simply there to acquire protection under a BIT. It is our submission that the claimant purchased these shares for a nominal sum of $5,000 US, when the shares were a few years ago valued at almost $300 million US.
But isn't that valuation an open market valuation as opposed to intra-company valuation? I mean, it's not untypical, is it, for there to be transfers between corporate entities in the same family?
At Tribunal, we do, Madam Arbitrator, we do recognise that it is not unusual for the value to perhaps be taken into account when there is an intergroup restructuring. However, we would submit that given there is the gap in the evaluation of the goods and the amount paid of over $295 million, this is demonstrative of the fact that it was not a legitimate transaction.
If the purpose of the restructuring was purely for tax, would your submission be the same, that we should regard it as an abusive process?
Tribunal, we recognise that if it was purely for tax, it would depend on the individual wording of the bilateral investment treaty. So we note that perhaps other treaties may include economic activity or control and tests as a means to perhaps bypass these, particularly manipulations of the corporate structure. And we would submit that in any event, an abusive process does not does not obtain protection under a BIT.
So just on the $5,000, isn't it arguable that it's reflective of the value of the company at the time at which it was transferred? Because at that point in time, one could say the company was already worth less money because the dispute was brewing and thereby damaging the value of the equity in that company.
We do recognise that there may have been a reduction in value, but as our submission, given the substantial reduction in value, is not equivalent to what may be, does not reflect perhaps the loss of value to the brand after the changes in law, or in anticipation of the changes in law, rather.
Counsel, would it be wrong to characterize the transfer of shares as a substitution rather than a sale? Is there any distinction between those two at all?
We would submit that the shares were assigned for value.
But inside the company itself, and you agree in the share purchase agreement that that's a possibility?
Tribunal, we do recognise that the share purchase agreement provides for who the particular shares in the company can be transferred. However, the share purchase agreement does not state that any transfer, particularly a transfer that is in breach of obligations under international law, would somehow be validated.
How is it breach of an obligation under international law?
Well, it's our submission that human treaties are required to be interpreted in good faith, which should not allow for individuals to engage in an abusive process. A transfer which we characterise as an abusive process is in fact such a breach.
The transfer that you've agreed to prior to it happening is an abusive process.
At Tribunal, the particular wording of the SPA simply states that the shares can only be assigned to members of a particular group. It's our submission that a valid assignment will be recognised under the SPA, however, an invalid assignment is not afforded protection under the SPA.
What is the definition of an invalid assignment?
It will be our submission that an assignment which does not occur, which occurs by way of an abusive process, would not be.
I have a feeling we're engaging in a circular argument.
Just any further, sorry, Tribunal, how may I particularly address your concerns?
Probably we might just rely on your written submissions on that point now. We'll go to the next one.
Thank you, Tribunal. I will now address the matters arising out of the share purchase agreement, and will establish that the Tribunal does not have jurisdiction to hear claims arising under the share purchase agreement on two grounds. First, that the actions of the State Property Fund are not attributable to the Respondent, and as such do not fall under the terms of the Article 6.2 of the BIT, alleged by the Respondent to be an umbrella clause. And secondly, that in any event, the ICC jurisdiction clause of Article 14 of the SPA bars this Tribunal's jurisdiction to hear the matter. As a preliminary point, we do not contest the characterisation of the Respondent as Article 6.2 as an umbrella clause, merely that in this circumstance we are challenging both that the actions of the State Property Fund were not the actions of the State, and secondly, that the ICC jurisdiction clause acts as a bar. To turn to attribution, referring to the Respondent's written submissions, we note that they have raised two concerns under the Articles on state responsibility, which have been invoked by a number of tribunals to consider whether or not actions of non-state entities may be nevertheless attributed to the state, for example in the case of Mathesini. It is our submission that neither Article 5, or the so-called functional test, as outlined in Mathesini, or Article 8, the referred to as a control test, are able to attribute the actions of the State Property Fund to the Respondent. To turn first to Article 5, which outlines that in order for actions to be the actions of the state, they must be exercises of governmental authority, we would note two particular matters in this case. First, that and if I may direct the Tribunal to page 29 of the record, paragraph 5 of Procedural Order Number 2, it establishes the fact that the State Property Fund is under, firstly, no direct control of the state, although we do concede that the state retains the ability to allocate members of the board. It does not state that the fund has any particular control over it by the government. And in particular, we would note the fact that in fact the fund is under no obligation to pass benefits from the sale of its assets back to the government. We therefore submit that the characterisation of the claimant in the statement of claim at paragraph 6, that this is in fact a privatisation, is false. Because in order to establish that there has been a privatisation in this case, it would have to be demonstrated that the proceeds from the sale had flowed back to the state, being able to be put to the purpose established, or alleged rather by the claimant, of balancing the books of the state.
Councillor, what is the full title of the ILC articles?
The responsibility of states for internationally wrongful acts.
Is transfer of state property to a state fund, which is there to manage a state property, an internationally wrongful act?
Of course not, Tribunal. And we submit, however, that it is the allegation of the claimant that the Respondent has engaged in in a breach of treaty, which under the Articles on State Responsibility would constitute an internationally wrongful act. Furthermore, the absence of any words expressed in the treaty in Article 6.2 to determine what are in fact the obligations and actions of the state mean that the Tribunal should look to other ways of interpreting that particular language, in particular to customary international law, such as the Articles. We would note in particular the treatment of those rules of attribution from the International Court of Justice in the Nicaragua case, as outlining that those rules are very strongly...
The Nicaragua case was about genocide, wasn't it?
It was not about genocide, the Tribunal arbitrator, rather. It was about the instruction of the US government on particular groups in Nicaragua.
It was funding the contrary rebels, which then conducted killings, mass killings in villages. It's arguable that was genocide or not, but let's get out. Still, it was an obvious manifest breach of an international obligation. Is transfer of state property to a state fund an obvious manifest breach of an international obligation?
Of course not, Tribunal. And indeed, it is our submission that, although I would note first, that in fact the state did not transfer property to the state property fund. If I may direct the Tribunal's attention to page 2 of the record, at paragraph 5, it states that the brewery was always the possession of the state property fund when it was enacted in 1928. Therefore, no such transfer occurred. But secondly, if I may address the Tribunal's concern as to the applicability of the ILC articles, the attributed elements of the ILC articles are of general application in international law, and thus the Tribunal in Mathesini, for example, applied those rules to establish what particular actions of a state entity would constitute actions of the state for the purposes of their responsibility under various treaties, including in this case the Umbrella Clause. Furthermore, I would draw the Tribunal's attention to the case of CSOB, where it was said, I'm sorry, did
many questions, but...
in the case of CSOB, the Tribunal considered the actions of the Czech Republic in privatizing particular, privatizing assets in an attempt to transition the economy from a communist economy to a capitalist market economy. In that case, they stated that it was not, the actions of the similarly titled state property fund were not attributable to the state, despite the fact that the state had issued an ordinance some days prior that stated that the selling of assets was now permissible. Instead, what the Tribunal viewed was that the actions of the state in making that ordinance were simply to now permit new activity by businesses. The fact that the businesses may now choose to take advantage or to not take advantage of that particular new regulation was a private matter for those businesses, not necessarily indicative of the fact that they were exercising elements of governmental authority. And indeed, in that case, they concluded that it was not an exercise of governmental authority, despite the similarity in the facts.
Counsel, does paragraph 6 of the record use the word that the state is permitting the sale, or is it saying that the state decided to sell?
We submit that at no point does it establish that the state decided to sell FBI. At paragraph 6, it states that the government decided that a number of assets should be privatized, but never establishes that the sale of FBI is done either. I apologize for that. Oh, sorry.
What is the next sentence? Could you please go on reading?
It says, as a result, I presume a typo, in the beginning of 2008...
I assure you it isn't a typo.
I meant grammatically, I apologize. As the result, in the beginning of 2008, the State Property Fund of Ruritania decided to sell the brewery. It is our submission that, in line with the CSOB case, the fact that as a result of a government directive, a private entity then takes upon a particular action to now take advantage of a new regulatory scheme, despite the fact that that may be towards some broader governmental purpose, or rather the purpose behind that ordinance was the sale of assets, does not indicate governmental authority.
Okay, thank you. I'm afraid you're out of time. Thank you very much for this session.
Thank you, Chair.
Claimant.
Thank you, Madam President, members of the Tribunal, and esteemed colleagues from the Republic of Ruritania. My name is Mitch Moranis, and I will be addressing the jurisdiction of the Tribunal and the admissibility of the submitted claims before my co-counsel, Rajarshi Banerjee, proceeds to discuss merits and damages. Before turning to Respondent's objections to jurisdiction, Claimant first wishes to emphasize that it meets the plain language articulations of investment and investor under Article 1.1 and Article 1.3 of the treaty. These are the primary sources for determining whether or not the investment qualifies under the VIT, and they are clearly met here. Article 1.1 enumerates shares of companies and intellectual property, particularly trademarks, which is the entirety of Claimant's investment in Ruritania, and Article 1.3 defines investor as the owner, possessor, or shareholder of investments. As previously mentioned, Claimant has made an investment, and Claimant is the owner, possessor, and shareholder of that investment. Turning now to Respondent's claims, Respondent suggests that Article 31 provides a source of good faith. Claimant submits that the reference of good faith in Article 31 simply goes to treaty interpretation. It's not an independent source by which to evaluate the conduct of Claimant in investing. However, for the purposes of argument, Claimant will stipulate that the investment must be in accordance with good faith. Claimant stipulates that the investment was made in accordance of in good faith because it was done prior to any dispute arising and certainly prior to a dispute existing. The respondent mentions the tribunals in Phoenix and Pac Rim, and both of those cases are illustrated with the question of timing and its relevance to abuse of process. In the Phoenix case, a claimant purchased a company that had ongoing domestic litigation against the Czech government for the sole purpose of internationalizing the claim. That was a clear abuse of process because the dispute was ongoing. That is the type of abuse tribunals should be concerned with. In Pac Rim, a company had been denied permits for mining in El Salvador and subsequently transferred the shares. After transferring the shares, the president of El Salvador, President Saca, made a speech in which he said that there was a de facto ban on mining, thereby essentially saying that the denials of the permit prior to the share transfer had been potentially acts violating El Salvador's bilateral investment treaty. However, the tribunal found no abuse of process because Claimant was not aware of the fact that a de facto ban on mining had been in place at that time. Here, at the time that Claimant acquired the shares from Pontifica Spirits, it simply knew that the New Wave Party had been elected and that the New Wave Party had an anti-alcohol stance. There was no sense whatsoever of the severity of the MAB Act restrictions, and there was no indication at all of trademark restrictions. And Claimant's primary submissions on the merits will relate to the trademark restrictions.
Counsel, can I just clarify? Do you accept that one of the factors, at least, if not the major factor in the restructuring, was in order to avail the company of investment treaty protection?
Yes, Madam Arbitrator. Claimant submits that it did transfer the shares for investment treaty protection. However, Claimant submits it was not an abusive process or a violation of good faith because it did so long before a dispute had arisen or a dispute was foreseeable with a very high probability. That's the language that the Pac Rim Tribunal adopted. Claimant wishes to draw the Tribunal's attention to the definition of dispute. The International Court of Justice has defined it as clearly held opposite views regarding the performance of treaty obligations. Professor Schroyer, in an article, What is a Dispute?, says that it must ascend above a general grievance and be stated in a concrete claim. Claimant submits that the concept of dispute and a future specific dispute within Pac Rim relates to the idea of essentially buying claims or transfer shares incorporating in a country for the purpose of accessing bilateral investment treaty arbitration. And at the time Claimant acquired the shares, that was not the case.
I mean, it might be said, though, Mine, that whilst one might have known exactly what was going to happen when the new government came into power, that one was anticipating some kind of dispute, even if not knowing exactly the very nature of the dispute. What would you say to that?
Certainly, Madam Arbitrator. Claimant submits that it did not know of any dispute. It knew of a perhaps tougher regulatory environment with respect to alcohol, and as a reasonable investor, that is something that Claimant could reasonably expect. The purpose of bilateral investment treaties is to attract investment. That is why Respondent entered into a bilateral investment treaty with Kronos, to bring investors like Claimant into the jurisdiction. And so Claimant, in seeking the protection of the treaty that Respondent has put forth to attract that investment, was not abusing process in any way. Claimant would like to further emphasize, as the Tribunal pointed out, the assignment clause, clause 11.1 of the share purchase agreement, allows for the transfer of the assets within the Pontifica Group, exclusively within the Pontifica Group. And Respondent pointed out that the substance of the transaction is important. The Tribunal in Phoenix mentioned substance, but only secondarily to the issue of timing. It was to prove that the fact that the timing was suspicious was justifiable in addition to substance. Here, where there's no concern over timing, and we have a clause consenting to the assignment of the asset, there really is no concern about the substance of the transaction, that it was sold or transferred for the nominal price of $5,000.
So you can see that you're in agreement with the other side that there was only a nominal price paid and no other capital expenditures happened?
Yes, Mr. Arbitrator, and Claimant submits that the record is silent on whatever accounting reasons or internal purposes that Pontifica Spirits transferred the shares for $5,000.
Will you spend anything else later on?
Subsequent to the share transfer, Pontifica Asset Management has had to reconfigure its bottling line in Mauritania because of the severe restrictions that they've undertaken. Turning now to the claims relating to the share purchase agreement. Respondent submits that they are not attributable under Articles 5 and 8 of the International Law Commission's draft articles on state responsibility. Before proceeding to that, however, Claimant just wishes to clarify an issue related to Article 6.2 of the BIT, which it seems both parties agree is an umbrella clause, and Respondent has waived their argument with respect to the fact that it is an umbrella clause that covers all obligations. They do, however, at one point mention a distinction between sovereign and commercial actions of the state property fund, or of states for the purposes of Article 6.2 and umbrella clauses generally. And Claimant just wishes to emphasize that that distinction is not appropriate because of the clear language of Article 6.2, which states that the contracting state shall fulfill any other obligation it enters into. That is quite clear and accords with the language in numerous other cases where tribunals, in accordance with BCLT Article 31, have found that it covers contractual obligations. The distinction in the first place was developed by two tribunals, the El Paso and Pan Am tribunals, where two of the three arbitrators were in fact the same. It's a distinctly minority approach, and the majority of tribunals do not make a distinction between sovereign and commercial actions. Turning now to the International Law Commission's draft articles on state responsibility. With respect to Article 5, which states that an entity's actions are attributable when that entity has been empowered by the internal law of the state to exercise governmental authority, Claimant submits that here, pursuant to a privatization scheme, it was exercising governmental authority. Both the tribunals in Noble Ventures and Hellman Hotels, which concern privatization, found that privatization pursuant to a scheme, a mandate of privatization, is an exercise of governmental authority. Turning now
So
to...
what do you say to the point raised by the respondent in relation to profits coming back into, in fact, not coming back to the government?
Madam Arbitrator, the record states that, yes, there is not necessarily, the record is silent on the question whether or not there is an obligation. However, the facts and circumstances of this specific sale indicate that the benefits of the sale will in fact pass to the government. Subsequent to the financial crisis, the government of Mauritania faced a substantial budget deficit. It directed the state property fund, that was the language, directed the state property fund to sell FBI for the purposes of filling that budget deficit.
So where is that language in the contract?
Oh, sorry, not direct, my apologies. Direct is not the language. As a result is the language that we agreed on, which Claimant submits is a strong indication of causality. There was a budget deficit. As a result, the state property fund sold the brewery and its intellectual property, and that then would transfer to the government of the Republic.
Is the government liable for any possible debts of the fund?
Mr. Arbitrator, in the event of default, the state would be liable for the debts of the fund. However, Claimant does not submit that that is a relevant consideration for the purposes of attribution, though it does indicate a close relationship and perhaps should create a presumption of a close relationship between respondent and...
So where does it say that they're liable for the debts?
If you will oblige us with a moment of time, lead to procedural order.
So maybe while you're in council,
Thank you. I can proceed. Thank you very much. Turning to the issue of Article 8, which states that an entity's actions can be attributed when that entity is acting under the direction or control of the state. Respondent is the 100% shareholder of the state property fund and is responsible for appointing the board of governors and the director of the state property fund. That should create a presumption of control given its substantial authority over the structure and management of the state property fund. Claimant does submit that ILC Article 8 requires that the specific conduct at issue, in accordance with the Nicaragua case, be attributable to the state. The state must be responsible for the specific conduct. And here, I'll get to it in a moment. Here, Claimant submits that the specific conduct at issue was directed by the state in terms of directing it to sell or needing to fill its budget, and as a result, the state property fund selling it for the purpose of filling the government's financial needs. And because of this full structural control as well as the facts of the case, Claimant submits that under ILC Article 8, the actions are attributable. And Claimant would like to point out that the actions may be attributable under either Article 5 or Article 8. The tribunal does not necessarily have to find both. Mr. Arbitrator, the information you seek can be found on page 29 of the record in Procedural Order Number 2, paragraph 5, which states that the fund may make periodic distributions to Ruritania, and in the event of its dissolution, all its assets and liabilities pass to Ruritania. Claimant submits that that is not necessarily relevant for the purposes of the structural and functional test. However, it does indicate that there's a close relationship between the two entities. Turning now to Respondent's argument regarding the exclusive forum selection clause found in the share purchase agreement. That forum selection clause vests jurisdiction over disputes arising under the share purchase agreement for the International Chamber of Commerce in Geneva. First, Claimant wishes to emphasize that it does not submit to bring a contractual claim into this arbitration. It will be submitting a claim of a breach of Article 6.2, which is a separate treaty claim. And therefore, there's no concern about the forum selection clause because it is a different standard. Thank you. Second, Claimant wishes to emphasize that the share purchase agreement was entered into between Pontifica Spirits, Claimant's predecessor in interest, and the State Property Fund of Ruritania acting on behalf of the state. Pontifica Spirits is incorporated in the state of Posteriana, which does not have a bilateral investment treaty with Respondent. Claimant submits that the purpose and inclusion of that dispute resolution clause was to provide Pontifica Spirits an international forum if any dispute arose under the share purchase agreement. However, after the share purchase agreement has been assigned to Pontifica Asset Management, there is no concern of providing an international forum because of the Kronos Ruritania BIT. Even though the share purchase agreement was entered into subsequent to the BIT, it was not a rejection of the BIT because the party which it initially entered into the share purchase agreement with did not have a bilateral investment treaty with Respondent.
Is it your submission then that if your client had owned the shareholding from the very beginning, that it would not have included an ICC clause in the agreement because it would have relied entirely on the treaty protection?
Madam Arbitrator, it's hard to say what my client would have done in hindsight. However, the clause would seem to be redundant in light of the broad language of Article 6.2, which would allow Claimant to bring any contractual breach under the BIT through Article 6.2. For the foregoing reasons, Claimant submits that the Tribunal lacks jurisdiction, Claimant submits that the Tribunal has jurisdiction over the submitted claims, and that the Tribunal has jurisdiction over claims arising under the share purchase agreement because the share purchase agreement is attributable to the state, and the umbrella clause assimilates all contractual obligations into treaty obligations, and a breach of the share purchase agreement would be a breach of the umbrella clause. Furthermore, Claimant submits that the exclusive forum selection clause does not preclude the Tribunal from exercising jurisdiction over any contractual claim because it can be brought through Article 6.2. And I will cede my remaining time. Thank you. If the Tribunal has no further questions.
Just one question.
Certainly.
If we don't agree that we have jurisdiction, is it possible for Pontifica Spirits to be joined to this claim?
Is it possible for Pontifica Spirits to be joined to this claim? As Pontifica Spirits is not currently an investor within the meaning of the BIT, Claimant would submit that Pontifica Spirits could not bring a claim under the BIT. The BIT clearly states in the present tense that an investor is the owner, possessor, or shareholder, not a former owner, possessor, or shareholder. And therefore, Claimant believes it is the only entity that could bring such a claim. Thank you.
Do you have any further questions?
I just have one question.
Certainly.
I just want to understand the kind of investment that we're fighting over. I mean, is it your case that the shares that were acquired for nominal $5,000 is the investment that was made by your client?
No, Mr. Arbitrator. Claimant submits that the investment is the brewery and its intellectual property, not simply the $5,000.
But the investment that was made, I mean, at the beginning you told me that the investment was the purchase of the shares, and the shares are owned by the company, so that the shares reflect the company that owns the brewery.
The treaty in Article 1.1 doesn't define investment as the act of acquiring. It defines them as shares and intellectual property, and defines investor as the owner, possessor, or shareholder of intellectual property. So therefore, the investment the investment is the shares and the intellectual property.
Okay, and what was acquired was the shares and the intellectual
That's
property
correct.
for an amount of $5,000.
Pursuant to Clause 11.1 of the share purchase agreement, those assets were transferred within the Kentucky group.
Okay, but it was $5,000.
Claimant does not submit it. It's back on the record. There's $5,000. Thank you very much.
Okay, so we now have 1 minute left.
Tribunal, in brief, I will bring two submissions in rebuttal. First, regarding the case cited by the claimant in favour of disproving an abusive process on the present facts, Pack-Rim came out. In that particular case, it was stated, if I may draw the tribunal's attention to the words of the tribunal in that case, that what is required is not the foreseeability of a specific dispute, or that the specific dispute need not have arisen. What is required is when the investor is aware that events have occurred that negatively affect its investment and may lead to arbitration in the future. And in doing so, made reference to the difficulty that tribunals may have in circumstantially establishing that such intention exists, but may nonetheless look to the factors mentioned by my co-counsel. In regards very briefly to attribution, it is simply the submission, firstly, that Article 8, as per the discussion in the International Court of Justice case in Nicaragua, requires not just the provision of assets or a general framework of control or direction. What is required, in fact, is a much higher burden, whereby the actual acts that are undertaken were as a result of the direction of the state, and in particular in Nicaragua, the court drew a distinction between the groups that had been given mere assets and the other ones that had been given actual direction, and identified only the latter's actions that were attributable to the state. And we submit that there is simply no evidence on the present facts that that kind of directional control exists. Finally, and just in terms of the application of Article 6.2, as per the Tribunal's decision in SPS in Philippines, it established that what an umbrella clause does is, in the words of the claimant, elevate the statement of the claim, the contractual claim, to be itself a breach of treaty. It's our submission that active elevation does not strip the obligation of the added restrictions that are on the enforcement of that right, in particular Article 14 of the Shared Purchase Agreement, and was in fact found by the Tribunal and SPS in Philippines that such an exclusive jurisdiction clause would act to bar a BIT tribunal's jurisdiction. As I know my time has expired, if the Tribunal has no further questions, that concludes my rebuttal.
May I begin? Whenever you're ready. Thank you, Madam President, members of the Tribunal, my esteemed colleagues. Good afternoon. My name is Rajesh Banerjee, and I'll be presenting claimants' arguments pertaining to merits and damages. This is a case about a state that has failed to fulfill its obligations, thereby devastating a reasonable investor. Over the course of the next 21 minutes, claimant will submit that, number one, the respondent has violated several substantive provisions of the BIT, which we'll get to Articles 2, 3, and 4 shortly. Number two, the respondent owes claimant moral damages for the unlawful arrest and detention of Messrs. Goodfellow and Strock. And number three, the respondent owes claimant damages for the losses suffered by claimant's subsidiaries and upstream suppliers located outside Mauritania. Unless this tribunal directs otherwise, claimant will begin by submitting that respondent has violated the fair and equitable treatment, or FET standard, under the BIT. Article 2.1 of the BIT asks or requires respondent to accord claimant's investments fair and equitable treatment, At the very outset, Claimant notes that past tribunals have considered two distinct standards for fair and equitable treatment. Regardless of the standard that this tribunal chooses to apply, it is likely to find that when a host state engenders certain legitimate expectations among reasonable investors regarding the legal framework surrounding their investments, only to then shatter those expectations, such conduct constitutes a violation of fair and equitable treatment. And that is precisely what we have here with the trademark restrictions that were a part of the NAB Act. In March 2010, when Claimant invested in Ruritania, as a member of the alcoholic beverages industry, it could have expected regulation related to when and where alcohol can be sold, purchased, and consumed. However, no reasonable trademark owner in Ruritania, not even in this industry, would have expected that they would not be allowed to use their trademarks on the very products that those trademarks are meant to sell. And this is largely because, for at least a decade and a half before March 2010, Ruritania was a member of the World Trade Organization and thereby a signatory to the TRIPS agreement, Article 20 of which states that signatory states shall not unjustifiably encumber trademark use by imposing restrictions that may keep consumers from differentiating between two different goods. Now, Respondent might note that the TRIPS agreement may be tempered by the Doha Declaration on TRIPS and Public Health, signed in 2001 by World Trade Organization members. However, that declaration deals specifically with flexibilities in patent law with regard to access to essential medicines in the world's poorest countries.
So regardless of what the provisions of the TRIPS agreement require, did they have jurisdiction to even look at TRIPS agreements?
Mr. Arbitrator, absolutely. This gives Claimant the opportunity to clarify how the TRIPS agreement is being used here. A violation of the TRIPS agreement would be, of course, for the World Trade Organization's own dispute settlement problem to deal with. However, when we're looking into what may inform a reasonable investor's legitimate expectations, we can look to this treaty that Ruritania itself had signed a decade and a half ago and point to that as informative of reasonable expectations. Article 31(3)(c) of the Vienna Convention on the Law of Treaties says that an interpreter of a treaty shall take into account all relevant international law that is applicable to the relations of the parties, the signatory parties of the treaties. Here, both Ruritania and Kronos were members of the World Trade Organization long before they signed this VIT. Despite this TRIPS agreement, several months after Claimant's investment in Ruritania, Respondent completely changed its regulatory framework surrounding trademark use for alcoholic beverage producers. That dramatic change in their framework, despite having signed on to the TRIPS agreement, violated Claimant's legitimate expectations and thereby constituted a violation of fair and equitable treatment.
But it could be said, couldn't it, that this claimant went into its investment with its eyes open, which was reflected by the price it paid. That in fact, it's not uncommon for a new government to do the very thing which it complained of, which is to act in a way that's completely inconsistent with what the government before did.
Madam Arbitrator, Claimant will not disagree at all with that reasoning. The New Way Party did have a political manifesto, but as we can see, there was no specific discussion as to trademark regulation. We merely knew that they had a much debated anti-irresponsible drinking stance. There was some discussion about the sale of alcoholic beverages in sports venues. Claimant does not challenge those segments of the NAB Act. Those it could have expected as a reasonable investor. Therefore, Claimant only limits its claims to the trademark restrictions that were found within the NAB Act. Claimant also submits that Respondent enacted several measures that were either arbitrary or discriminatory in violation of Article 3.1(c) of the VIT. Claimant specifically submits that the Rehan Ordinance was an arbitrary measure and that the bottle size restriction of the NAB Act was a discriminatory measure. Beginning with the Rehan Ordinance. The Rehan Ordinance, enacted by Respondent Ruritania, was enacted on the basis of a scientific study, so egregious in its mistakes that it should not serve as the basis for any reasonable government regulation. Past tribunals, most notably the tribunal in Methanex, did go into the scientific study underlying a regulation to see if the resulting regulation was arbitrary or not.
Counsel, do you think this tribunal, without help from an expert, is competent enough to consider the scientific soundness of a test?
Mr. Arbitrator, 2 points in response to that question. First of all, this tribunal is empowered to bring in experts who may consider peer-reviewed literature in order to aid it in its determination. But even without experts in this room right now, Claimant can point to a superficially obvious mistake with this study. This study, which went on for a period of 10 years and claimed that a certain chemical found in Rayhan found in one of Claimant's beers, and Claimant's counsel might have difficulty pronouncing this chemical.
Let your client identify.
Certainly. It claimed that this chemical may pose certain cardiac health risks. However, the people behind this study didn't look into whether the subjects of the study had any prior cardiac health history. This is egregious for a scientific study, especially one that had gone on for this long, one that had followed its subjects for so long. And therefore, the resultant state measure should be deemed as arbitrary because of the egregious mistakes in the study. Claimant also submits that the bottle size restriction within the Act that restricted bottle size for alcoholic beverages such as beers to 0.5 liters was a discriminatory measure, again in violation of Article 3.1c of the VIT. As the Tribunal in Salupa noted, a discriminatory measure is one that treats parties in similar circumstances differently without reasonable justification. As this Tribunal looks into what parties in similar circumstances might be, Claimant would like to direct this Tribunal's attention to the guidance offered by the Tribunal in S.D. Myers. There, the argument concerned companies that disposed a certain chemical waste, PCB. The Tribunal didn't define similar circumstances so broadly as to consider any company that deals in chemical waste, and it certainly didn't define it so narrowly as to only cover the investor in that case, which was exporting PCB for processing. Taking that into account, Claimant submits that other beer producers, those are the companies that were in similar circumstances as Claimant. Vodka, whiskey, other kinds of spirits, they may have also been subject to the bottle size restriction. However, they have different alcohol content, different consumption patterns. They do not directly compete with beer for consumers. And for that reason, given the S.D. Myers standard, the Tribunal should limit itself to other beer-producing companies. Now, a government measure that treats parties in similar circumstances differently isn't alone a discriminatory measure. We must also have a lack of reasonable justification. And Claimant will submit today that there was no reasonable justification with the bottle size restriction in particular. The purpose of the MAB Act, as reported by Respondent, was to reduce alcoholism, excessive alcohol consumption. Not excessive consumption of beer per se, excessive alcohol consumption. And the bottle size restriction restricts bottle size without taking into account alcohol content per volume. It is legal today, after this bottle size restriction under Mauritanian law, for beer producers selling beers with triple the alcohol content of our light brew to sell those beers legally to consumers in 0.5-liter bottles. That does very little to address the issue of alcoholism, excessive alcohol consumption. Now,
Counsel, is there any precedent for limiting the sign of a beverages contained in other jurisdictions?
Mr. Arbitrator, Claimant takes note of a certain measure passed by the New York City government regarding soft drinks in that case and bottle size. And it is, to the best of Claimant's knowledge, no tribunal got to go into that measure. A court struck down that measure on constitutional grounds. That would be an American law matter that Contemporary law is.
What was the reasoning of court there? Which article of the U.S. Constitution was being breached?
My apologies there, Mr. Arbitrator. Claimant is not familiar with the court's specific decision in that case, but if this tribunal really needs to be acted with there. And again, if that is an issue that deals with the U.S. Constitution, we must go into what Mauritanian law might say on that matter as well to gauge how discriminatory these measures were in order to have justification. Article 3.2 of the BIT allows arbitrary or discriminatory measures provided that they were meant to protect public order. At the very beginning, claimant will note that this is a non-self-judging clause, meaning that it is not for a respondent state, but for this tribunal to determine what a threat to public order is. And claimant requests that this tribunal consider the definition for public order accepted by the Tribunal in Continental Casualty versus Argentina on the recommendation of the Argentinian state. The state there said that a threat to public order, it could be a riot, an insurrection, a violent threat to the stability of the state. That is quite distinct from public health. The reason why this tribunal should consider a narrow definition is because what we have here in Article 3.2 is an exception. If we define this exception too broadly, states may pass any number of arbitrary or discriminatory measures that will go on the
In considering an exception, are we not required to apply the doctrine of margin of appreciation to state policies?
Mr. Arbitrator, absolutely. States should feel free to regulate in order to protect their citizens, and tribunals should not go into granular detail regarding regulations. However, here we have a case that has tied itself to this arbitrary or discriminatory standard, so it is well within the tribunal's authority to consider whether the measures were arbitrary or discriminatory. The states may, of course, feel free to enact any number of non-arbitrary, non-discriminatory measures, and their public order exception doesn't even come into play. Claimant also submits that the trademark restrictions, again, of the NAB Act, indirectly expropriated claimants' Mauritania-registered trademarks in violation of Article 4.1 of the BIT. Article 4.1 prevents host states from directly or indirectly expropriating investments. Claimants will note that trademarks are distinct investments under Article 1 of the BIT. Past tribunals, when assessing indirect expropriation, have considered three factors that this tribunal might find helpful. The first is whether an investor's legitimate reasonable expectations were violated. As already stated in the context of FET, they were violated with these trademark restrictions. The second is whether an investor was either substantially deprived of control of its investment or substantially deprived of the economic value of its investment. Economic value gets to the quantum of damages, something that we can deal with in the second stage of these proceedings. With regard to control, claimant submits that it no longer has the ability to use its trademarks on the very products that they're inextricably linked with, on the very products that they're meant to sell. It may still conceive of some limited use of its trademarks, which is why claimant wishes to direct this tribunal's attention to Inmaris Verstrika versus Ukraine. In that case, the investment was a ship, a cruise ship. Its purpose was to travel around Europe with passengers. The government of Ukraine put a travel ban on that ship, just keeping it docked. Claimant still had legal title. It could still use the ship for certain limited purposes. People could walk around the ship. However, the tribunal there held that there was an indirect expropriation.
So isn't there a difference here? Isn't the inherent nature of a trademark right prohibitive in the sense that you are not allowing others to use your brand rather than positive that you exercise your brand?
No one else can use your brand still. It's still the case that no one else can use your brand.
Yes, Madam
You still
Arbitrator.
have control over that brand.
Madam Arbitrator, yes. Madam President, as Mr. Arbitrator noted, claimant still contains negative rights. Other people can't use claimant's trademarks, just as other parties could not use Inmaris's ship in Inmaris versus Ukraine. But that does not mean that there hasn't been substantial deprivation, given that part of being able to use one's trademark, part of the value of these trademarks, especially as enshrined in Article 20 of TRIPS, is to be able to use these trademarks on the products that they're meant to sell.
Still, there is a difference, isn't there? That the main part of the right of ownership of the ship is using the ship, not stopping others from using it. The main part of your right in using a trademark is actually stopping others from using the trademark.
Yes, Mr. Arbitrator, trademark law does concern itself with these negative rights of trademark ownership. However, in looking at how investors use their trademarks and how investors use these investments, we must be aware of where these trademarks derive their value from, and that is with being associated with certain products. That is what gets to the value of this intellectual property. And by being deprived of this use, claimants will also submit that there has been a deprivation of value, something we can get to in related to quantum of damages. Article 4.1 does allow for legal expropriation provided that four strict conditions are met, one of which is that there must have been a compensation. There has been no compensation here. So in the interest of this tribunal's time, Claimant will submit that this was an illegal expropriation under the clear text of the treaty. Claimant further submits that Respondent owes Claimant moral damages for the unlawful arrest and detention of Messrs. Goodfellow and Straw. At the very outset, it is agreed between the two parties, it's on the record, that there was a violation of full protection and security. That is the hook in the BIT with which these claims come in. That leaves the argument to whether moral damages ought to be awarded in this case. Past tribunals, recognizing their authority under customary international law, given ILC draft articles mention of moral injury, given the famous decision by the PCIJ in the Chorzai factory case that all consequences of the legal act may be wiped out. Past tribunals, taking all of this into account, have awarded moral damages in, as the Lemeray Tribunal noted, exceptional circumstances, and the Lemeray Tribunal noted that illegal detention could be an exceptional circumstance. That has led to harm, including loss of reputation, fear, stress, and anxiety. It is true that these damages may be speculative, which is why they're brought in under the moral damages heading, as the Tribunal in noted. Just because we may not be able to put a dollar, pound, or euro value on these damages does not mean that they are very much palpable.
Fear, stress and anxiety are things that individual human beings feel. Is it really something that a claimant, a corporation can feel that one should be compensated for?
Madam Arbitrator, this brings us to the full protection and security, again, the hook under which this came in. The presence of the word full under full protection and security suggests that the state ought to provide the complete suite of protections it can to an investment. An investment will be of little use if the employees required to work that investment are kept from doing so. A factory would be of little use if it was untouched but all its employees were incarcerated. In the interest of this tribunal's time, Claimant will finally submit that Respondent owes Claimant damages for the losses suffered by Claimant's subsidiaries outside Mauritania. Claimant acknowledges that there is a certain definition of investment in Article 1 within the text of this treaty. Claimant will also note that this BIT, like most BITs, do not mention damages outside the context of expropriation, but that has not kept past tribunals from awarding damages to make an investor whole again for other breaches of the BIT.
So you mentioned Article 1. Which of the prongs of Article 1 covers damages to subsidiaries?
Mr. Arbitrator, what we are focused on here is the fact that the losses to the subsidiaries do not count as a separate investment, but are, as the NAFTA Tribunal in Karyl noted, inextricably linked to the investment in the whole state, in the whole host state. This is given the global nature of our current economy. This is given the global nature of procurement networks. Any injurious measure by the state was immediately felt by these immediate upstream suppliers, supplying hops, barley, aluminium, other things essential for beer. And for that reason, the Karyl Tribunal, working with a similar definition of investment under NAFTA Chapter 11, awarded damages for the losses suffered by the subsidiaries. And for the foregoing reasons, and in the interest of time, Claimant seeks the following relief from this tribunal.
Before you go there, counsel, are you under any obligation to mitigate your losses?
Certainly, and Claimant will submit that it has gone to great length to mitigate its losses. It reconfigured the bottle production line of its most iconic beer in order to satisfy the bottle size restriction. It sent a letter to Mauritania noting the mistakes in the study behind the Rehan Ordinance, and it tried to amicably settle this dispute before finding itself today before this tribunal.
What did you specifically do with reference to the subsidiaries?
Mr. Arbitrator, the record, to the best of Claimant's knowledge, appears to be unclear with regard to those subsidiaries, and in the absence of more information, Claimant cannot be sure as to what its crime, what it specifically did. But it will note that given that it went to other great lengths to mitigate damages, one may assume that it went to great lengths in other spheres as well. And for those reasons, Claimant requests this tribunal find that it has jurisdiction over all claims. Those claims are admissible. That Respondent has violated several substantive provisions of the BIT, owes Claimant moral damages, and owes damages for the losses of these subsidiaries, which were inextricably linked to its investment. Thank you.
tribunal, I will be concerning the two arguments on the merits that are before this particular tribunal, namely the issues raised in regard to expropriation and a breach of fair and equitable treatment. And I know that my co-counsel will then deal with the issues regarding moral damages and the losses of the claimant's subsidiaries. If I may make a small amendment to our written submissions, I will deal with the submissions of the claimant in the order in which they raise them orally, and first deal with the fair and equitable treatment standard, and subsequently the expropriation, rather than it appears in our written memorials. In terms of the in terms of the fair and equitable treatment standard, the respondent agrees, or would rather note that the claimant has not incorrectly noted the standards that they need applied under the fair and equitable treatment standard, despite the disagreement of tribunals as to whether or not fair and equitable treatment adopts some sort of meaning in customary international law. But for the purposes of this proceeding, we'll adopt the meaning given it by the claimant, and we'll address the concerns raised by the claimant on the 4 grounds upon which they allege that the fair and equitable treatment standard was breached. First, in reference to the legitimate expectations of the investor under the MAB Act. Second, in terms of the asserted discriminatory effect of the measures. And finally, turning to the arbitrary treatment or proportionality assessment by the claimant under both the Rayhan Ordinance and the plain packaging scheme. I do apologise to the tribunal if I've missed any of the claimant's arguments. I'll be happy to address them in questions. To turn to the first ground upon which the claimant alleges there being a breach of the fair and equitable treatment standard, that is legitimate expectations, I would draw the tribunal's attention to 2 particular matters on this front, in demonstrating that even if the investor did have legitimate expectations regarding, in particular, its intellectual property rights, these expectations cannot be viewed as legitimate in all the circumstances. First, the claimant predominantly invoked the TRIPS agreement and other kinds of international agreements that the claimant and, the claimant's host state, Kronos and Mauritania, had entered into. It is our submission that TRIPS and other WTO agreements, such as the SPS Convention, all envisage the capacity of the state to invade particular intellectual property rights in the instance that the measures address public health. And it is the submission, therefore, that any expectation that the investor had that his intellectual property rights could not be violated for that purpose was plainly illegitimate on the facts. Furthermore,
so if my understanding is correct, they did not claim that you had not a right to interfere with their rights. It was the issue that your interference should be reasonable.
And I will turn, if the tribunal prefers, to the issues of proportionality in terms of the legitimate expectations. In terms of the plain packaging scheme, we submit on 2 grounds that that particular scheme was entirely proportionate. And first, I would like to make reference to, I believe, the question that the arbitrator was referring to when he mentioned the margin of appreciation, both in terms of the South African Constitutional Court and the European Court of Human Rights, both of which, despite being bodies specifically tasked to analyse the proportionality of governmental measures, have always expressed reticence to impugn particular measures as proportionate or disproportionate. And therefore, we submit that the tribunal should give significant scope for the government to implement measures that it feels are in the best interests of its country. But furthermore, we equally submit that the plain packaging scheme was proportionate in the current circumstances. In particular, we note that a number of jurisdictions around the world, including Uruguay and perhaps more infamously Australia, have introduced plain packaging schemes for potentially harmful products. It is the function of those schemes to ensure that no nefarious advertising can be used to mask the harmful effect of those products. In particular, I would like to draw the tribunal's attention to the World Health Organization report on the consumption of alcohol, which stated that it was extremely important to curb marketing of alcohol in terms of the way in which that may potentially affect matters of public health. They not only noted that marketing should be targeted, but also explicitly mentioned that a reduction in bottle size may similarly attempt to curb influences such as alcoholism or excessive drinking, by virtue of the fact that, although perhaps not the most logical of consumers, alcohol consumers would, when presented with a serving size of a smaller amount than they would previously purchase, would not purchase further bottles, and therefore would overall consume less alcohol.
Counsel, how do you address the point made by the claimant in relation to the fact that size isn't everything, and that it's all about the content of the alcohol content, and therefore one might make regulations in relation to the size of the container, but actually it would be much more proportionate and much more, have much greater influence in terms of trying to achieve your objective if you concentrated simply on the quantity of alcohol.
We submit that, perhaps to speculate somewhat, drinking cultures surrounding different kinds of alcohol is expressly different, and that beer is a substance that is consumed readily and in large quantities, whether other kinds of alcohol may be consumed in smaller quantities. And equally, it is not feasible for the claimant to simply increase the alcohol concentration in particular types of alcohol. Usually the concentration of alcohol is linked to the type that it is, for example, a spirit versus a beer. But secondly, we would submit that on the grounds that this could...
Nancy, all beers share the same alcohol content?
Usually, unless they are classified as light, medium or heavy beers, they all contain approximately the same.
Is it possible to raise the alcohol content?
Only on a significant change to the recipe. The infancy of light beer is that it has nothing compared to the taste of other kinds of beer.
Since you raised the Australian cases, was there any measure regarding the number of cigarettes in the packet?
I am not aware totally on other kinds of packaging restrictions that have been introduced by the Australian government. We would in particular note there have been significant packaging restrictions on the form of the packet, such as the material it may be made out of, and also the fact that massive warning labels must also exist on the labels that deter potential consumers from consuming it. However, I'm not aware as to the number of cigarettes that are contained within the particular packets. However, in turning back to the Madam Arbitrator's question regarding proportionality, it is simply the submission that in terms of attempting to address a particular harmful effect of the culture surrounding the drinking of beer, the respondent introduced specific measures attempting to curb that particular measure. Notwithstanding the fact that they may not be effective in other kinds of consumption of other forms of alcohol, the respondent simply submits that as a battle for another day, and then in the short term, if in particular the issues raised by beer can be addressed, then that should be the aim of government. Perhaps I may also turn to the concerns of the tribunal regarding, or the claimant rather, concerning discrimination in terms of the differential effect of the measures. And I would in particular draw the tribunal's attention to the case of Lauder, where it was stated that more is required than simply differential effect of a particular measure. For example, it could be in respect of the Rayhan ordinance that it is solely the claimant's product that is posing a harm to public health. In the Methanex tribunal, for example, it was just that particular additive that was potentially infringing public health, not other kinds of additives in its class. But what the Lauder tribunal in particular discussed was not just differential effect, but that it must be based on some sort of prejudice or preference. In that case, they were able to identify that a preference for aliens, or rather, in that case, a fear of foreign ownership in its country, would constitute such a ground of prejudice or preference. Whereas in this case, there is clearly a ground upon which the claimant's investments have been targeted, as they pose a particular risk to public health. We would note in particular, in terms of the Rayhan ordinance, that, for example, in the case of Methanex, the tribunal held that it would not be discriminatory or otherwise arbitrary treatment to rely on a scientific study, notwithstanding the fact that that scientific study may have been disputed in its specific terms. And we submit, additionally, that there is no significant evidence that the findings of the HRI report are invalid, merely perhaps that in certain instances the claimant has been able to find scientists to disagree with it. And it is still not arbitrary for the state to rely on a scientific study. The standard of arbitrary treatment we submit is higher.
What do you say to the claimant's argument, though, that on its very face it was plainly flawed? If you just look. And let's assume that the report is found to be seriously flawed. Does that matter for the purposes of your argument? Are you saying, provided in a sense the state's acting in good faith and reliance on it, it shouldn't be regarded as arbitrary if it's in fact seriously flawed analysis on which the entire act is based?
If the tribunal believes that the state is acting in good faith in the enactment of a measure, then to impugn that same action as a breach of the standard of fair and equitable treatment, we submit would be beyond that particular standard. But equally, if I may draw...
That was the question. Was it in good faith, regardless of the validity of the test?
And we submit, of course, that the measure was enacted in good faith as a result of the fact that...
Even if you find out that the test was faulty, because you've acted in good faith, everything is fine.
Well, I would address the arbitrator's concerns on two grounds. The first is the fact that the measure itself is not as faulty as depicted by the claimant. There is still significant evidence of the fact that the substance, methyldioxybenzoate, may still be harmful in some quantities. The accusations of the claimant do not hold up against all of the findings of the study. But furthermore, if I may draw the tribunal's attention to page 4 of the record, paragraph 15, the warning labels are proportionately representative of the findings of the HRI report, as the labels only state that as a result of scientific research, Rayhan concentrate may lead to a higher risk of cardiac implications. It does not state that the ingredients will lead to cardiac complications and do not constitute bad.
Was this study on the Rayhan concentrate?
Sorry, Dr.
Because the label, you said the label reflects the study. Was the study on Rayhan concentrate?
It was on methyldioxybenzoate, which appears as 80%.
So the label does not reflect the study, does it?
It reflects the fact that 80% of Rayhan is in fact methyldioxybenzoate.
Where is that?
It is in one of the procedural orders tribunal. I believe the tribunal, the procedural order number 3, after going through the classification of Rayhan as from the Basel family, it goes on to page 34. At paragraph 12, establishes that there are 0.8 grams of methyldioxybenzoate in 1 gram of Rayhan concentrate.
Counsel, should this tribunal take into account the potentially devastating impact of having a warning, which basically says this is going to give you a heart attack if you drink it? Should we take that into account in assessing whether or not it was appropriate or we should consider it arbitrary or unfair for the government to have acted on a medical report that perhaps, or simply one lot of research rather than a number of reports from a number of scientific advisors? Should we be taking the impact and consequence of your action into account in assessing what standard we should hold you to in relying and acting upon this particular report? Is that relevant?
Well, we submit that, yes, in terms of assessing whether or not a measure is proportionate, what should be assessed is the range of measures that are available to governments as to whether or not it is, for example, in the words of another tribunal, necessary in all the circumstances. However, we submit when considering the other actions of government, for example, as the government as the Californian government in Methanex did, banning a particular substance, the government has in fact acted proportionately, as all it has sought to do in this particular instance is inform consumers of a study that may suggest that there are possible risks of consuming a particular product. Merely giving information to consumers with which they use that information to discern whether or not to consume a product is plainly not disproportionate in the present circumstances. I note that my time is very rapidly expiring. If the tribunal perhaps has no further questions on fair and equitable treatment, may I turn to the questions of expropriation?
I think actually you're out of time, so I think we'll read about expropriation and we'll hand over to your other speaker to continue with issues for
Thank you.
Thank you, Madam Arbitrator. I will be addressing the remainder of the issues, particularly relating to damages, namely the capacity of the claimant to seek moral damages and compensation for the harm suffered by its subsidiaries. The claimant today presents 2 objections to the capacity of the claimant to seek moral damages. Firstly, we submit the tribunal should not follow pre-existing decisions and make an award for moral damages, and it does not fall within your jurisdiction. Secondly, we would note even if the tribunal was to come to a conclusion that it could in fact make such an award, the degree of harm suffered by Mr. Goodfellow and Straw does not in fact meet the standard required to make such an award tenable.
Counsel, before you go into that, do they have jurisdiction to consider breaches of the FPS argument?
Sir?
Do they have jurisdiction to consider breaches of the full protection and security obligation?
And tribunal, if I refer you to the treaty document itself, when it refers to breaches of full protection and security...
Which page is that?
Sorry, that is on page 11 of the record. 11, and the paragraph number is 21B. Now, what the full protection and security obligation expressly refers to is full protection and security to investments by investors. And Mr. Arbitrator, this essentially comes to the thrust of the submissions that Mr. Goodfellow and Straw neither constitute investments nor investors, and as such, so do not have independent claims to come forward before this tribunal. It therefore does not appear rational that the claimant can subrogate these non-existent claims and seek compensation on their
Is
behalf.
claimant's reputation part of the investment?
Tribunal, if I may refer you to the procedural order on page 26 of the record. Now, I would submit that perhaps the claimant has mischaracterised the particular claim as contained in this record. What this record states is that they are seeking moral damages which may in principle be awarded by the tribunal to the claimant for the arrest of Mr. Goodfellow and Straw. It is not seeking moral damages for the harm that it itself as an entity has suffered, rather it is seeking damages for the harm suffered by these two individuals. So as such, the impact of the arrest and investigation on the reputation of the claimant is not in fact what they are seeking damages for, and as such should not be allowed to.
Is there anything in the ancestral rules that bars them from amending that claim?
Tribunal, to the best of my knowledge, in the 2006 Untitled Chapter law, there is actually no direct provisions which outline how a party could amend a claim.
Sorry, so your submission is that the applicable rules are the 2006 rules?
Tribunal, in accordance with the procedural order. Sorry, in
I think
accordance.
it might be helpful if you took us to the procedural order.
Yes, so in page 26, Article 3 of the procedural order, which expressly states that it is acknowledged and concerned that the procedural law of the aptly named Fairyland, in all respects which are identical to 2006 Untitled law.
Have the ancestral rules been amended? Does that have any effect?
We do concede there has been an amendment of the Untitled laws, and there was recently a 2010 Untitled law issued. We don't state that as the tribunal is bound by the particular laws of Fairyland, which are the 2006 law, those are the ones that are applicable. If there are no further questions on that issue, I'll move to the partial matter.
I may have a question. Just, I mean, the test that we've been asked to look at is the second last bullet on page 26, right?
Sorry, yes.
And so the question is whether moral damages may in principle be awarded by the tribunal to claimant for the arrest of Goodfellow and Straw. So the question is not for us to determine whether Straw and Goodfellow actually suffered. The question is whether the company in one way or other suffered. Are you with me on that?
I understand the tribunal's concerns, and we would concede that the award, it's whether it states that moral damages may in principle be awarded by the tribunal for the arrest of Mr. Goodfellow and Straw. It particularly refers to the arrest itself and the harm imposed on those individuals, as opposed to moral damages suffered by the claimant themselves.
The problem that we have is that it's very easy for a government to start harassing the employees of an investor and make it impossible for the investor to do what it hopes to do in the country, to conduct its business in a proper manner, and for the employees end up being in jail. It would be rather difficult for the foreign investor to do anything about it. And the question that we have as a tribunal is, how could we help, in principle, investor in those circumstances?
Tribunals our submission that if there was evidence of perhaps a campaign of harassment by a host state against an investor, the treaty documents themselves would provide a wide raft of available remedies for them, namely, for example, breaches of the discriminatory standard and also general principles of fair and equitable treatment.
And that put in full protection and security standard as well.
Well, given the full protection security standard is limited to that affecting the investment, it is our submission that that it would be limited to, it would not be applicable in this instance.
So if, for example, having your senior executives paraded on TV and arrested had a negative impact on your reputation as a company, that's not something we should take into account in assessing claims by the claimant in this case.
Tribunal, we concede that moral damages may be awarded for the harmed reputation, and that's well recognised since the Lusitania decision and also in the ILC draft articles. And we're submitting that the problem the respondent has with the submission of the claimant is that they're not in fact seeking reputational damage that they themselves have suffered. They are seeking compensation for the harm suffered by the two individuals. And it is our submission that falls outside the bounds of the treaty
But
documents.
Counsel, 2 points. First, they're not arguing that. They are just saying for the arrest, not for the harm to the individual caused by the arrest. So that's a different thing. And secondly, they raised the Desert Line Yemen case. How is this one distinguishable from that one?
I've raised 3 concerns in response to your questions to arbitrator. I'd first state that the Desert Line and Yemen case and also the Lamia case outlined by the claimant both refer to moral damages suffered by representatives as distinct from moral damages suffered by the company itself. So we'd argue that those cases do in fact support our proposition that the claimant is seeking harm for the employees as individuals as opposed to reputational harm. Now, whilst we do concede a number of tribunals have recently recognised they do have jurisdiction to make such an award, we believe those decisions are not consistent with the fundamental principles of how an arbitral tribunal should construe its jurisdiction under the investment treaty.
How?
Tribunal, given the fact that the investment treaty is limited by object and purpose to investment and capital inflow and outflow, it does not extend to the harm suffered by individuals in their personal capacity.
So what is the object and purpose of this specific treaty?
It is our submission that the object and purpose of this particular treaty, if I may refer to the preamble, is intending to create favourable conditions for investments by investors of either contracting state in the territory.
Is a preamble the only place that we can distill the object and purpose of a treaty?
Well, it is our submission that in the preamble is perhaps the best way to determine what the object and purpose of the
Is there
treaty is.
any article in the current BIT before us that talks about the right of individuals, for example, the right to sojourn and
No tribunal. We believe that this treaty is wholly focused on investors and investors.
there is no article in the treaty that talks about the rights of individuals.
Unless an individual themselves is classified as an investor, then perhaps the rights may be protected. But individuals that are not classified as investors fall outside the protection of the treaty itself. Tribunal, moving on to knowing that my time is fast escaping me, I'll quickly move on to address the...
Could you, Council, go to Article 3.4 of the BIT on page 12?
Article 3, 4. Yes, Tribunal. However, it is our submission once again that that is not the particular claim the claimant is seeking to bring today.
So that informs the object and purpose of the treaty, doesn't it?
Well, once again, Tribunal, essentially what this provision is concerned with is allowing the investment itself to function, as opposed to allowing the tribunal to have jurisdiction to make an award for individuals that do not ordinarily fall under the protection of the BIT.
It's part of allowing an investment to function, not arresting the executives of the business.
Tribunal would submit that where it is a valid exercise of state authority to arrest the executives of the business, that would not be precluded by this treaty itself. Otherwise, it would essentially hamstring the state's authority to conduct prosecutorial and criminal investigations. Tribunal, briefly moving to the submissions of the claimant on the application of the Lemire test, whilst they may have noted that that the test requires exceptional circumstances, what they failed to inform is that this test requires that cause and effect both be grave and substantial. And it's our submission that the conduct of the investigation, the detention of the individuals, would not in fact meet this grave and substantial harm. And it was noted in Lemire as well that an ordinary breach of full protection and security could not necessarily justify an award of moral damages. At Tribunal, I'd briefly like to move to my submissions on the capacity of the claimant to make compensation for its subsidiaries. And we will note that these bodies constitute separate legal entities, and as such are neither investors, and the claimant would have to demonstrate they would constitute part of their investment in the host state. Whilst the claimant has averted to the decision of Karyl, thank you. We would expressly note that paragraph 144 of the Karyl decision expressly states that the entities were seeking compensation for the harm suffered by the subsidiary in the host state itself. The fact that it was referencing harm outside does not necessarily means that it was not precluded under the BIT. What the claimant is seeking to do is to seek compensation for body that is located outside of the host state and has no affiliation with it. Thank you, Tribunal.
Right, well each side is now going to have 1 minute rebuttal. I'm going to give you both 1 minute just to collect your thoughts. And I will invite the claimant to do so. the during the rebuttal we will not interrupt your questions. Okay. Thank you. Right, please.
If you're ready. Thank you. Claimant will take a minute to stress one point. Respondent today has relied on the Australian Clean Packaging Act and the Uruguayan Clean Packaging Act. To the best of Claimant's knowledge, the Australian law was enacted in December 2011, a full year after the MAB Act, a full year and a half after Claimant invested in Mauritania. And therefore, and the Uruguayan Act being in these two laws could not have informed a reasonable investor's legitimate expectations in March 2010. With that, Claimant will cede the rest of its time and thank us for your time. Thank you.
Thank you very much.
Tribunal, in addressing an issue that is very close to home for the respondent bench, I would only note the Tribunal's decision in the Parkering's case, where it was stated that a general regulatory environment or a general, for example, sale contract for particular assets did not itself give rise to legitimate expectations. What is required is actually a representation on behalf of the state that they will not enact particular legislation, not as asserted by the claimant, that legitimate expectations may arise by virtue of the certain regulatory environment being the way it is. And in that case, the Tribunal held that changes in the taxation system, despite the fact that they were not previously announced, did not form part of a legitimate expectation of the investor, and as such, the state did not breach the fair and equitable treatment standard. That concludes my sorrow.
Thank you very much. I'd like to thank Council for their presentations under enormous pressure. I think the pressure is greater from the fact that your peers are in the audience than anything we might be asking at the bench. What will happen now is that each member of the Tribunal will just give a few short comments to each side, and then we will be adjourning to deliberate, and then we'll keep you in suspense for a while, and then at the award ceremony, the will be announced. Okay, so I'd like to invite any comments, Adrian?
Well, thank you very much. I very much enjoyed both your presentations. Some of it was very refreshing because I sort of saw a new way of looking at investment treaty law. Which is not to say it's not meant as any criticism, but that was very interesting and helpful from my perspective. I think one of the things that I found very helpful from both sides was a sense of the justice of the situation and whose interests ought to be protected by this arbitration tribunal. I mean, it's that kind of thing which will ultimately persuade me when I occasionally have the opportunity to sit as an arbitrator. But that's also something that you can do more and more of. Why am I right? Why is it what I'm proposing to the arbitration tribunal to determine is the right thing? And the other thing that I very much liked from both counsel was your attempt to try and be helpful to the arbitration tribunal, because that's what I think is good advocacy, is that you try and convince and help the arbitration tribunal to render the right decision. So thank you very much for that. And I just have to say, well, one thing that I did recognise was the last point, which was the Parkering's case, because that is, in my experience, a fantastic case for states, and it's something that I would have expected much earlier and not at the very end. I mean, that's a point in time, by the way, where I felt I recognised investment law 100%. Thank you.
Thank you very much. It was a great session. It was marvelous to see how the things that we thought of, because I was involved with the writing of the problem and then writing of the bench brief, and probably this is now a good moment in time to thank everyone who was involved with it. I know all of you enjoyed the case about here in Germany. So especially I'd like to thank Sergei Kasolowsky, who was running the show with the problem, and he's unfortunately not here, and Dr. Potocznik for helping with the bench brief. But it was really nice to see how everything came to life, how you guys were looking into the traps and points that we put in the problem, and how you need some of them, including the one in the BIT. And it was also interesting to see the different styles in advocacy. Two completely different styles, one more passionate, one more measured. Both of them very interesting. Thank you for a lovely session.
I thought the standard of advocacy was extremely high, and I would say that in investment treaty arbitration as a whole, the standard is often not very high. And it's wonderful to see that the next generation will be so much better